Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning David Griffin, 301682. Today is Monday, December 23rd, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
David Griffin, 301682.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Hannah Dean for the record on behalf of Mr. Griffin. Good morning, sir.
Good morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend a revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Griffin, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. Good. First, I will read you your rights. Then we will review the parole violation charges that the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
Thank you. We now will review the charges that the state your parole officer is bringing against you and the information underlying each charge. Charge 1, halfway house placement. On October 11th, 2024, you were released from Osborn Correctional Institution on special parole supervision and placed at a halfway house. During your intake process, you read and signed your halfway house agreement and special parole conditions, indicating you understood the expectation that were placed on you for community supervision. After completing your intake, you informed the halfway house staff that you were supposed to / wanted to go to Open Hearth Halfway House. You proceeded to walk out of the halfway house without permission from parole or halfway house staff. You left at 1:49 p.m. and returned at 5:20 p.m. Your whereabouts in the community were unknown for about 3 hours and 31 minutes. You are in violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. On October 13th, 2024, you came to the staff office at 4:40 p.m. to return the house cordless phone and stated, I'm not going to lie, I'm leaving. You proceeded to walk out the halfway house without permission from the halfway house or staff, or halfway house staff or parole. You returned to the halfway house at 11:28 p.m. Your whereabouts in the community were unknown for 6 hours and 48 minutes. You are in violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. On October 15th, 2024, you voluntarily walked out the halfway house at 2:20 p.m. with a bag in your hand. Halfway house staff tried to call you back into the building. You replied to staff by saying, I'm gone, I'm not coming back. You are in violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. The state's exhibits were marked and identified on the record at your preliminary hearing held on November 5th, 2024. Counsel, did you receive the notice of parole violation report, and the other documents that were marked for identification purposes?
Yes, we have.
And defense has also found in Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Thank you. As to the charge, I would just state that this is somewhat of a difficult situation that Mr. Griffin had shared with me. He reports that upon admission to the Cheney halfway house, it wasn't the supportive environment that he was hoping it would be. He noted that there were a number of known triggers in that environment, and he was trying hard to avoid them. He felt that it wasn't supportive of his success. That's my only comment as to the charges, and at the appropriate time, I would like to speak as to his background and future plans. Thank you.
Thank you. On charge 1, halfway house placement, I make a finding based on state's exhibits B, C, and F through J. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Thank you very much. Mr. Griffin is 38 years old, born and raised in the Hartford, Connecticut area. His primary source of support are his sisters, Shakira and Jessica. He has suffered significant loss. His father and brother both recently have passed away. His father was actually battling cancer. That's been very difficult for him. He has 4 children, 3 of whom reside in Connecticut. 1 lives in Jacksonville. He has a GED, got that in 2003. Most recently, while in the community, he was actively searching for work. Last employment was part-time in 2020 at the recycling center in Hartford. He was in that position through a temp agency for approximately 9 months. While incarcerated, my client reports that he's been on the waiting list at Osborn to try and get a job there. Upon reinstatement of his special parole, he would like to be placed at Open Earth if possible, or a halfway house in the Hartford area. He also is open to a halfway house in Waterbury otherwise. After successfully completing a halfway house, he's interested in trying to go through the Connections REACH, Reentry Assisted Community Housing Program, to try and get his own housing set up. After securing a job, he's also interested in enrolling in trade school to study electrical. He wants to work as well with a temp agency for immediate placement at a job. He's super interested in working for the Trader Joe's Warehouse world-class distribution center that's located in Bloomfield. He's also amenable to any sort of treatment that's recommended by the hearing examiner and board, including successfully completing Explore. And also he's looking forward to doing individual therapy. I would ask that he be re-paroled prior to his EOS date, just so that he's able to establish some services in the community, including housing, treatment, and things of that nature. So I would just ask for a sanction that gets him out before his EOS date so he can do that. Thank you very much.
Thank you. I'm going to take a moment before I announce my findings. Okay. Okay, Mr. Griffin, being that this is your 4th violation, this is your 2nd violation where you have left the halfway house without permission. You were in the community for approximately 12 days. And of those 12 days, 8 were unknown, being that you left the halfway house, I want to say around day 4. With that said, I recommend revoke with no new re-parole date, which is an approximate 9.5-month sanction. In the event that the board chooses to lessen the recommended sanction, I recommend the following conditions: no consumption of alcohol, domestic violence, no contact with victim, AP, halfway house placement, and mental health evaluation. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on January 2nd, 2025. So on January 2nd, 2025, the board is going to take a look at your case. They could lessen my recommended sanction. They can't exceed it because I recommend no new parole date, but they can lessen it if they choose to do so. But again, the board has the final decision, and they will make that decision on January 2nd, and you will receive written documentation of their decision.
And Mr. Griffin, if you want to give me a call that day, I can let you know what the board decides, and we can discuss any questions you may have.
Yes, so I'd like to ask, what's the sanction? Again, you gotta explain the sanction.
So I recommended no new parole date, which means you would go to your end of sentence, which is on August 22nd, 2025. But the board can lessen that recommendation. If they agree with, they have the option to agree with it or lessen it. But the decision will be officially made on January 2nd.
All right.
Okay. All right. Thank you so much.
Yeah.
All right. Take care, sir. Happy holidays.
Yeah.
Good morning.
Good morning, how are you?
Good. What is your name, sir?
Glenn Gagnon?
Okay, thank you.
No problem. Uh-oh.
Good morning. My name is Officer Saunders. I'm a hearing
morning.
examiner for the Board of Partisan Paroles.
Mhm.
This is a preliminary hearing concerning Glenn Gagnon, 223-789. Today is Monday, December 23rd, 2024. This is a hearing being conducted via video at the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DLC inmate number for the record.
Glenn Gagnon Jr., number 223-789.
This is a public hearing. Public access to this hearing is available via video live stream. Now, I noticed on your parolee rights, you indicated that you did not want to proceed with a preliminary hearing. Is that still your intent?
It don't matter, either way, whatever's easiest.
Well, it's up to you. I mean, your parole officer recommended the top program. So if you were
Yes,
to
ma'am.
waive this first portion, we would just go right into the top diversion process. So if you
I'm already in
waive,
it.
okay,
I'm
so do
already
you
in the
want to?
top, I already started.
Okay, so do you want to waive the first portion and we just to officially grant you the top program through our process?
That's fine, whatever you
Okay.
guys want to do, cool.
So before I accept your waiver, the first
Mhm.
part of this preliminary hearing, I first have to go over the rights with you, which you are waiving today.
Yes, ma'am. See out there cussing somebody out.
Oh boy.
Not cussing, playfully though, to mess with them.
So you're waiving the right to be represented by an attorney today.
Yes, ma'am.
You're waiving the right to receive written notice of the charges of violation.
Yes,
You're
ma'am.
waiving your right to review the evidence against you before this hearing.
Yes,
You're
ma'am.
waiving your right to submit evidence in support of your case.
Yes, ma'am.
You are also waiving the right to call and examine voluntary witnesses and to cross-examine adverse witnesses.
Yes, ma'am.
Okay, so you understand everything you just waived, correct?
Yeah. Mhm.
Okay. I accept your waiver and I have reviewed your case and made findings of probable cause that you have violated one or more of the conditions of your parole. And I do find that the acts are serious enough to warrant revocation. I have also determined that you should be detained while you wait for your revocation hearing. Now I will proceed with the second part of this hearing regarding the diversion process, which is the top program.
Yes, ma'am.
The Department of Correction has recommended you for diversion from the revocation process for substance abuse programming and treatment. This means that if you wish to participate and apply, and I find that you have met certain criteria, I can continue your case while you are provided with an opportunity to participate in substance abuse program and treatment in a correctional facility. If you successfully complete the program and treatment provided, I will dismiss your case and order your parole reinstated. If you do not complete the program and treatment provided, the board will schedule you and convene a revocation hearing to determine if you violated the conditions of your parole. If so, the hearing examiner will make a recommendation regarding whether your parole should be revoked and what, if any, sanctions should be imposed. The decision to participate in diversion is voluntary. Do you understand the diversion process and do you wish to apply?
Yes, ma'am.
I will now announce my findings with respect to your eligibility. If I determine that you are eligible, I can accept your application and divert you from revocation. I have reviewed all relevant information and my findings are as follows. I find that you have no pending misdemeanor or felony charges. I find that your discharge date is more than 60 business days from the date of remand to actual custody. I find that there is evidence that you have identified substance abuse treatment needs. I find that substance abuse is reasonably considered to be a motivating factor in your alleged failure to comply with the terms and conditions of your parole. And I find that there is some evidence that you received or were provided with an opportunity to receive substance abuse programming or treatment during your period of parole supervision in the community. I have determined that you are eligible for diversion for substance abuse programming and treatment. Yet, before I accept your application for diversion, I ask that you indicate whether you understand the following by answering yes or no. I understand that I will remain incarcerated while I receive programming and treatment and that parole revocation proceedings may be delayed as a result.
Yes.
I understand that the dismissal of my case and reinstatement to active parole supervision is not guaranteed and is conditioned upon successful completion of substance abuse programming and treatment.
Yes, ma'am.
I understand that ultimately the Department of Correction will determine whether I have successfully completed the substance abuse program and treatment provided.
Yes, ma'am.
I understand that my participation in this process is completely voluntary.
Yes, ma'am.
Your application for diversion is granted, and I know you're already participating in TOP, so you'll just continue and then,
Yeah. Unfortunately, I've done this before.
so you'll be diverted from revocation for no more than 60 business days. Okay, so this does conclude your preliminary hearing. Thank you.
Merry Christmas to you, ma'am.
You as
Have a
well.
good
Thank
one.
you.
I won't be so merry, but I'll learn something. Thank you. Look. Thank you.
Good morning, Mr. Caldwell.
Good morning.
So it's going to be probably like 15 minutes because we're going to have to wait for your attorney. She's in another hearing.
Okay, awesome. All right.
All right, all right. What's up, Mad Max? Man, I'm up early today, but man, I gotta go to work today. So I figured out like, man, I might as well just jump on right now before I gotta walk out the door and get some of these streams going. I see that they're not gonna have anything for tomorrow, so this will probably be the last parole board hearing this week at least for Connecticut. I gotta check those other states to check if they got anything going on. Hopefully everybody's doing good today and are gonna be with their loved ones tomorrow. I know I am. So whether I like it or not, so so I'll be off this week, starting tomorrow through Thursday. So I'm gonna check if I could get some other things going on. If I could possibly get Jesse, David, and Felipe, and I'm gonna hit up Javi to see what's up. How's he doing on his schedule? Maybe we could get some video visits going on in the next few days to see how the fellas are doing. If you're familiar with this channel, we do a wide variety of visiting prison streaming, whether it comes to phone calls, video visits, these parole board hearings. Individuals going through their life journeys and whatnot. So hopefully we could get something, coming my way and your way. And bring in the new year. It's pretty much this year is almost over, and now we're gonna be heading over to 2025. I'm definitely concerned about 2025, but let's see what happens. Anyhow, I'm gonna go ahead and get ready to work. I'm gonna leave the stream running, and I'll check in before I head on out. And hey, thank you guys for tuning in and supporting. Every bit helps. Oh yeah, and for those of you that just came in, they said it was gonna be about 15 minutes, about 3 minutes ago. Before they start this hearing, they're waiting for this gentleman's counsel or lawyer. So once he steps in, then I'm not sure if he's gonna step in, if he's gonna be over the phone or video or whatever. But that's what we're waiting for. So if you're wondering why it's quiet and he's just looking at his notes, that's what's happening.
Did you not commence yet? Yes. Down by the visitor room. Okay. Sorry about that, but I had to call J1 back because I'm like, weird. Well, the distance. As soon as I got back home. So this is what I think. I think they're gonna call this. Yes, I think this is what you're. It's right here. Oh, no. Afterwards, Good morning, my name is Parole Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Paroles Caldwell 212-897. Today is Monday, December 23rd, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office in Osborn Correctional Institution. Please state your full name and DOC inmate number for the record.
Good morning. So my name is Carlos Caldwell, inmate number 212-897.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Good morning, Hannah Dean for the record on behalf of Mr. Caldwell. Good morning, sir.
Hi, good morning. How you doing, Attorney Hannah?
Good. How are you?
Great.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Caldwell, please raise your right hand.
Sure.
Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes, I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officers, bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Thank you. You have important rights at this hearing, which I now review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call, and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, I do.
Thank you. We now will review the charges that the state your parole officers bringing against you and the information underlying each charge. Charge 1, GPS. On September 20th, 2024, you removed the GPS monitoring device from your ankle without permission of your parole officer, in violation of your signed GPS monitoring agreement. Charge 2, absconder. On September 20th, 2024, you signed out of the Chase halfway house for training at approximately 7:18 a.m. with an expected return time of 4:15 p.m. You never returned to the halfway house and never made contact with your parole officer. You do not have permission to reside at any of the residences. Your parole officer made multiple attempts to contact you via phone with no contact made. Your whereabouts in the community are unknown. And charge 3, halfway house placement. On September 20th, 2024, you signed out of the Chase halfway house to attend a training at the Manufacturing Alliance Service Corporation and the American Job Center at approximately 7:18 a.m. with an expected return time of 4:15 p.m. You never returned to the Chase halfway house. You do not have permission to reside at any other residences. Your actions violated your signed halfway house agreement. I will return to the halfway house from the community pass at my scheduled return time. The state has also filed the following exhibits. Exhibit A, remand to custody. Exhibit B, parole violation report. Exhibit C, parole violation notice and rights. Exhibit D, Chase halfway house agreement. Exhibit E, Chase halfway house incident report. Exhibit F, GPS monitoring agreement. Exhibit G, attendee GPS strap violation. And Exhibit H, signed parole conditions. Counsel, did you receive the notice of parole violation report, and the other documents I would just mark for identification purposes?
Yes, we have.
Thank you. Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement, as well as Defense Exhibit 2, letter of support from Margaret Mead. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Thank you very much. I would just note as to all the charges, just provide some context here. This is an unfortunate situation. Mr. Caldwell was doing really well in the community. Unfortunately, he has been experiencing a great amount of grief, particularly when these alleged violations occurred. He had left on a training pass on the specific date. He did have permission from the halfway house to go out on that training pass. While out on that pass, he received a call informing him that his grandmother, who he was very close to, had unfortunately passed away, and this really weighed heavy on him. He reports he had called halfway house staff to report that he was running late. I believe he had missed the bus. And while on the phone with them, had explained that he had gotten this call that his grandmother had passed and had inquired if he could be with his family, attend services in the future, and was told no. So I do just want to provide that context to these charges here. And at the appropriate time, I would like to speak to his background and future plans. Thank you very much.
Thank you. I'm going to take a moment before I announce my findings. Thank you. On charge 1, GPS, I make a finding based on state's exhibits B, F, G, and H. Charge 2, absconder, I make a finding based on state's exhibits B, E, G, and H. And on charge 3, halfway house placement, I make a finding based on state's exhibits B, D, E, and H. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Thank you very much. Mr. Caldwell is 49 years old, born in the Hartford area, raised in Manchester, Connecticut. His primary support in the community is his fiancee, Margaret Mead. She did, I believe, submit a letter of support as well. He also has received significant support in the community from staff at the Manufacturing Alliance Service Corporation, as well as his case manager, Karen, who he was working with at the Chase Center. Previously, while he was on special parole, Mr. Caldwell's mother passed away, unfortunately, and then most recently, as I mentioned before, his grandmother passed away. These both were significant stressors and significant losses for him. He has 3 children, ages 25, 26, and 27, who he constantly communicates with. He also has 1 stepson and 2 grandchildren. Most recently, while on special parole, when he was placed on special parole July of this year, he was placed at Community Solutions Halfway House Chase Center in Waterbury. Previously, he had completed the Connections Halfway House program at East Center successfully. He was there for approximately 4 months. And then after that, he was sponsored by his fiancee, Margaret, in Waterbury. In 2018, he completed 1 year of sociology courses at Pinnebog Valley Community College in Willimantic. While at the Eddy Center, he had began school at Middlesex Community College and had gotten a Pell Grant for school completed his FAFSA. Most recently, he got himself enrolled in Manufacturing Alliance Services Corporation in Waterbury. He was studying manufacturing and was attending full-time there 5 days a week. He reportedly obtained his OSHA 12 certification to become a CNC machine operator, and also reportedly attended American Job Center in Waterbury, where he was working with staff to brush up on work-related skills, taking different courses, including CPR and more. Significant experience working in the warehouse industry. Mr. Caldwell also reportedly worked around the Chase Center campus while there, as well as other program sites with other peers for cash on the weekends. Previously, he was working with Steadfast Staffing Solutions in Waterbury to obtain employment. Unfortunately, he hadn't been placed at the time of remand. Recent treatment episodes that he had completed while on supervision, he participated in Explore Domestic Violence groups at Wheeler. Those were held every Thursday, and he was about halfway through the program, I believe, at the time he was remanded. He was also working with the Connection. He was, I believe, waiting to start their Center for Problem Sex Behavior Treatment. The referral, however, was made. He was just waiting on a new start date. Previous treatment from December 2023 to January 24, he was doing individual therapy and medication management at WCT Behavioral Health in Waterbury. And he also had been from that same time period at the Connection Center for the Problem Sex Behavior Treatment. He also has primary care services established in the community. In addition to being paid for some of the tasks that he completed around Chase Center, he also reports that he was doing some volunteer work there as well. During his recent incarceration, beginning in November of this year, he has been employed in the clothing factory at Osborn Correctional. I also want to note from the DIS summary that we now receive, he has not had any tickets while incarcerated. The last ticket he had, I think, was back to 2008. So the most recent bout of incarceration, he has had no disciplinary issues whatsoever. Upon reinstatement to special parole, he would like to be sponsored by his fiancee, Miss Mead in Waterbury. He's also amenable, if that is not possible, to go to a halfway house, but he would ask that that be in Waterbury, so it's near his support system. He is also looking forward to returning to Manufacturing Alliance Services. He is hoping to, continue moving forward with the work he was doing there. He can reportedly return within a 9-month period. He also reportedly had job opportunities through friends. One was doing carpentry work, the other doing sheetrocking. He's amenable to any sort of treatment requested by the board, including returning to counseling, completing the connections treatment, and more. He's open to any sort of treatment that's recommended. He also does have medical doctor established at Trinity Health in this area as well, Waterbury. He also reports that he has an opportunity for future employment with his previous job developer from Career Resources, Warren Leach, sharing his story at community events. I would just note that this is a situation where there's no new cases. It's not as though he was out there picking up new charges. He, I think was doing very well in the community prior to this remand. He had gotten himself into schooling. He had been trying to take every possible opportunity to move forward with his employment and his skills. I would request that if there are any conditions placed on Mr. Caldwell, that the no contact with his fiance not be one of them. That is his fiance who he was residing with. This has created a variety of challenges, I think, for both parties, but both of them report no safety concerns and a desire to be able to move forward building their family. They were in the process of planning a wedding, I believe, so he is hoping that they can move forward without that no contact stipulation. I would ask for the least restrictive sanction possible and the soonest possible re-parole date for Mr. Caldwell so that he can return to what he was doing before at Manufacturing Alliance and all of the positive things he was doing in the community. And I believe at this time, Mr. Caldwell would just like to briefly make a statement.
Okay, thank you. Mr. Caldwell?
Good morning. Good morning again. How you doing, Ms. Saunders?
Thank you.
Officer Saunders.
Mhm.
So I'm kind of nervous a little bit because this is a very serious situation. I'm not proud of myself. It was a huge learning experience for me. I know, my wrongdoings, and I understand that what I did was not the right way or the correct way of handling things. But you have my word, man, that I will get my stuff together as far as understanding how to be responsible for making decisions and stuff. I was out in the community doing the best that I could. Attorney Dean has said, I was out there going to manufacturing school. I was volunteering in the Youth Alliance program to where we talk to wayward youths and try to get them to turn, into a better direction than what we had went in. I'm kind of nervous, like I said. I just want to be able to succeed and to continue on the work that I've already started. And I understand that I was wrong in my ways of my actions. I get that and I understand that. I just ask and beg for an ounce of mercy, considering that I have a network set up that is productive as far as helping me out. I'm an older gentleman, so I understand and I get stuff that I didn't before. And I just want to be able to continue my career that I've established and that I've started. I worked very hard for that. And I know that I can be prosperous and successful on high levels. Please just give me another opportunity. Give me this chance to be able to show and prove who I actually am. Thank you. I appreciate you guys.
Thank you.
Thank you.
Anything further?
No, thank you very much.
I'm just going to take a moment before I announce my recommendation. Okay, Mr. Caldwell, being that this is your 7th violation, this is your 4th time absconding, or 5th, 4 of those charges were absconding. You had 1 criminal. You were in the community for 2 months before leaving the halfway house, and your whereabouts were unknown for about 7 weeks. Based off of all that information, and taking into account also the loss in your family, which I'm sorry to hear, I recommend revoke and reparole on November 11th, 2025, which is an approximate 12-month sanction with the following conditions: no consumption of alcohol, domestic violence. I do know your request. I'm taking into account your request for the no contact with Miss Need to be removed. However, that's going to have to come from your parole officer for that request. So no consumption of alcohol, no complete domestic violence, no contact with victims, MM without the express permission of your parole officer, halfway house placement in the event that it is needed, mental health evaluation, and problem sexual behavior treatment. My recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on January 2nd, 2025. So on January 2nd, 2025, the board can lessen my recommended sanction. They can let my recommended sanction stand, or they can exceed my recommendation, being that you're on supervision until 2028. So, but you'll receive official written decision from the board after January 2nd, 2025.
Mr. Caldwell, I can set up a legal call for you that day on the 2nd so that we can discuss what the board decides and go from there.
Okay.
All right. Thank you
So
very
we
much.
don't talk-
Sorry.
Okay. Yeah, so we don't conference before the board, we conference after the board?
So we don't know for sure what they're going to do. The board can, like, Officer Sanders was saying, they can expand the recommended sanction, they could lessen it, or they can approve the recommended sanction. So I normally will schedule the calls for that day because that's when we for sure know what happens. But if you would like to speak with me before then, I can go ahead and email your counselor so we can set up a call to debrief this hearing if you would like.
Absolutely, I appreciate it, thank you. And I apologize for my behaviors. Thank you.
Thank you.
Thank you very much, sir. Take care and have a happy holiday, okay? I'll talk to you soon.
Yeah, thank you.
Thank you.
What?
Mr. Laboy, you waived your hearing, so you're not needed to be present today.
Okay, I wanted to ask a question, if that's cool.
Well, you have an attorney, so I just want to let you know this is your live stream. We're not on record, and you have an attorney. So, if you want to ask it, I don't know if I'll be able to answer, but because you do have an attorney.
Yeah, I know. I was just asking if it's possible if I can bond out and get put on a GPS, sent to a halfway house and fight my case. Signed.
So I would defer you to your attorney on that question.
Oh,
Okay.
Okay.
All right. Thank you.
All right. Have a good day. Bye. Oh, no, she told me that I was. That's fine.
Does he need to leave or he still needs to wait?
No, he's all set.
Okay.
Thank you. Good morning.
Hi, good morning.
So we only have Mr. Fiak.
I have, I have two persons, but you're
So we
only
don't
doing
need
one?
Anderson. We don't need Anderson. He's no longer having his hearing today. He waived, so we don't need him today.
Oh,
Just
okay.
Fiak. Yep.
Okay, so as soon as he comes in, I'll have him seated, okay?
Thank you.
All right.
And good morning.
Good morning, Mr. Fiak.
Yes.
My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Nikko Fiak 432772. Today is Monday, December 23rd, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Robinson Correctional Institution. Please state your full name and DOC inmate number for the record.
Nikko Fiak 432772.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Good morning, Public Defender Robert Famiglietti of the Parole Revocation Unit.
Good morning.
Good morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact to as each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. So my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony in today's hearing will be taken under oath. Mr. Fiak, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you.
You're welcome.
First, I will read you your rights. Then we will review the parole violation charges that the state your parole officers bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, I do not.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
Thank you. We now will review the charges that the state, your parole officers bringing against you and the information underlying each charge. Charge 1, obedience to the law. On October 5th, 2024, you caused significant damage to the victim's residence by damaging her belongings. You threw food throughout the apartment, gutted her refrigerator, and poured red liquid on the apartment floors. You harassed the victim at her friend's residence. When your victim attempted to escape your harassment by residing at a temporary residence, you were parked outside that location in your vehicle. When the police observed you in the vehicle outside the victim's temporary residence, you fled. On October 17th, 2024, you were arrested and charged with breach of peace second, family violence, stalking third, family violence, reckless driving, and interfering with an officer. On October 18th, 2024, at your arraignment, your charges were modified to breach of peace second, stalking second, physical safety, interfering with an officer, and criminal mischief first. The state has filed the following exhibits. Exhibit A, Connecticut conditions of parole. Exhibit B, remand to actual custody. Exhibit C, notice of parole violation, notice of parolee rights. Exhibit D, parole violation report. Exhibit E, New Haven police report and arrest warrant. Exhibit F, decision information summary. And Exhibit G, continuous minimus. The state filed an addendum to Exhibit D, which states on November 18th, 2024, Mr. Fiak pled guilty to breach of peace second and was sentenced to 6 months jail, execution suspended, followed by 15 months conditional discharge. He also pled guilty to interfering with an officer. He was sentenced to 9 months jail, execution suspended, followed by 15 months conditional discharge. The charge of stalking second, fear of physical safety was now laid under the docket ending in 612. Council, did you receive the notice of parole violation report, and the other documents I just marked for identification purposes?
Yes, I have.
Defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement, and Defense Exhibit 2, letter of support from Ms. Gloss. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
As he pled guilty in charge 1 to the breach of peace and interfering and received conditional discharge, I have no comment as to the preponderance standard. The stalking charge was clearly nollied because the elements weren't met in the allegations. There's no repeated conduct, so it's not a stalking. But he did plead guilty to a breach of peace misdemeanor and interfering misdemeanor for leaving the scene. Thank you.
Thank you. Regarding charge 1, obedience to the law, I make a finding based on Mr. Fiak's conviction, as well as State's Exhibits A, D, E, and G. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background and history. Counsel?
Yes, this allegation, there's no damage to any human beings here. There was no threat of violence. And there's no threatening charge. There's no assault of conduct. It's basically him damaging the property. He is a 24-year-old man. He receives his support from his mother, sister, nephew, brother, his brother's mother, their extended family, and some friends. He obtained his GED while incarcerated, NYI. He completed the New England Tractor Trailer Training School course in Bridgeport, and he has obtained his CDLA with the help of Project Longevity. He worked as a result of that for KRB Trucking for 4 months, and also another job, part-time seasonally, for 4 months at CK Greenhouse in Cheshire. He also completed various programs while incarcerated: financial literacy, anger management, conflict resolution, reflections, domestic violence, and also a COVID vaccine ambassador. He wishes to be sponsored once again by his brother's mother, Jennifer Jett, in East Haven. He's eager to restart his career in truck driving with his CDLA, and he aspires to own his own transportation business. At some point, I ask you to draw attention to the supportive letter from Ms. Gloss. I believe you've read it. I don't believe that these crimes are sufficiently serious enough to require further incarceration. He's been held now since October 17th. I know his end date is April 26th of this discretionary parole, but we'd like to see him supervised for some period of time before his sentence ends. I believe treatment is appropriate. The PO recommended a total revoke. He never actually met the PO that made that recommendation. She has no personal knowledge of him. He worked with PO Abdul Smith for the last year and a half. That PO left New Haven and transferred to Bridgeport, I believe, where he transferred to Bridgeport. He did phenomenally well with that PO. Obviously, that's not going to affect whether or not my client was arrested, but I think there should be some consideration. He had no graduated interventions or sanctions. And what we believe he needs is anger management treatment and not jail before his release on this sentence. Thank you for your time and consideration.
Thank you.
You're welcome.
I'm gonna take a moment before I know. Did you have something to say?
Oh, no, I said thank you as well.
Oh, okay.
You're welcome.
I'm gonna take a moment before I make my recommendation. Mr. Fiak, being that you were in the community for about over a year and a half, you didn't receive any misconducts that was reported in the PVR. However, you did receive a new conviction while on discretionary parole. With that being said, I recommend revoke with no new reparole date, which is an approximate 6-month sanction. In the event that the board chooses to lessen the recommended sanction, I recommend the following conditions: anger management, domestic violence, halfway house placement in the event that it is needed, Mental health evaluation, no contact with victim KG without the express permission of your parole officer, and no operation of a motor vehicle without the express permission of your parole officer. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on January 2nd, 2025. Now, on that date, the board is going to take a look at your case, and they can lessen it. They can't exceed it because that's the end of your sentence, but they do, they have the ability to lessen my recommended sanction, which is going to your end of sentence, which as of today is April 18th, 2025. Yeah, yep, it is April 18th. But on the second, after the second, I know you can contact your attorney to see what the board decided, but you'll also receive written decision from the board as well. Okay,
Yes.
so that does conclude your revocation hearing. And you're all set. Thank you.
Okay, sir.
Thank you.
So
Have a good day.
give us a call on January 3rd, okay, sir?
All right, we'll do. Happy holidays.
You too.
Tayari Anderson, inmate number 367352, waived his hearing for today. Therefore, there will be no hearing taking place regarding Mr. Anderson. Good morning.
Morning, how are you?
Good. I should be meeting with Mr. Johnson.
Johnson, okay.
Thank you.
Yep. Johnson, yep.
Good morning.
Good morning.
We won't get started probably for like another 5 minutes.
Okay,
Thank you.
thank you.
Good morning. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning William Johnson, 359818. Today is Monday, December 23rd, 2024. This hearing is being conducted via video at the Board of Pardons and Paroles Central Office in Garner Correctional Institution. Please state your full name and DOC MA number for the record.
William Johnson, 359818.
This is a public hearing. Public access to this hearing is available via video live stream. Also present this morning is your attorney.
Attorney Alfonzo Sirica, Public Defender with the Parole Revocation Unit on behalf of Mr. Johnson this morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Johnson, please raise your right hand. Do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
I do.
Thank you. First, I will read you your rights. Then we will review the parole violation charges of the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No, ma'am.
Thank you. You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes, ma'am.
We now will review the charges of the state your parole officer is bringing against you and the information underlying each charge. Charge 1, absconder. On June 14th, 2024, you left Chase Halfway House with a community pass with a return time of 11 a.m. You never returned. You do not have permission to reside at any other residences. Your whereabouts in the community are unknown. Charge 2, halfway house placement. On June 14th, 2024, you left Chase Halfway House on a community pass with a return time of 11 a.m. You never returned. You violated your halfway house agreement by not returning at 11 a.m. The state has filed the following exhibits. Exhibit A, remand to custody. Exhibit B, parole violation report. Exhibit C, parolee notice of parole notice of violation of parolee rights. Exhibit D, PCS conditions. Exhibit E, Chase Halfway House incident report. And Exhibit F, Chase Halfway House agreement. Counsel, did you receive the notice of parole violation report, and other documents that were just marked for identification?
Thank you.
And defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Yes, on behalf of Mr. Johnson, I know the first charge under absconder. My client is not disputing the fact that he left the facility on that date. He was paroled on August 25th, 2023. What is not in this parole violation report. My client suffers from a brain injury, received surgery. I'm not making excuses for my client. When he left on June 14, 2024, my client had received a very large settlement check from a civil settlement. And he had a dispute with the individual at the Chase Halfway House. I believe his name was Brian. My client was at the bank trying to cash this large check. And as you know, and as I know, you're only allowed a certain amount of funds in your account at the Halfway House. This was a check it was a 5-figure, very large check from a settlement. My client went on a drug binge, quote unquote, for a couple of months. He did not pick up any new charges, obviously. At the end of September, my client ended up in a psychiatric facility to get some treatment. And upon his release, as indicated here, he did turn himself in on October 2nd of 2024. Mr. Johnson, anything I just put on the record incorrect? Or is what I just put on the record the sequence of events from June to October?
Yes, sir. I was a little bit not to add and string it out, but I have a lot of brain damage from my 2 brain surgeries, so it's hard to like put together my PTSD and actually get treatment. So I have a lot of issues with my treatment because of my brain cancer. So I can't really make really good decisions on my own.
I will cover that regarding the camp that has come in the second part. Once again, Ms. Saunders, and not make an excuse for my client. I just want to give you a little background as to what happened here. But to his credit, as we can see here, there's no new criminal charges. Upon his release from the psychiatric facility, he did go turn himself in.
And what month to what month was he at the stuff?
He was there. He went in active user for a couple of months. Funds ran out. Ends up in the facility at the end of September for approximately 2 to 3 week stretch of time. But right upon his release, he turned himself in on October 2nd of 2024.
Thank you. Anything further?
Not regarding the first part of the hearing, no.
On charge 1 absconder, I make a finding based on state's exhibits B, D, E, and F. On charge 2 halfway house placement, I make a finding based on state's exhibits B, D, E, and F. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Yes, on behalf of Mr. Johnson, as I indicated, please take into consideration my comments that are already put on the record. Take into consideration the facilities currently being housed at because of his issues. He's at Garner. My client, he's 45 years old, did receive his primary source from his mother and his grandmother upon his previous release. August 2023 was a New Opportunities Halfway House program in Waterbury, and then he was immediately transferred for medical purposes for handicap accessibility. And then it looks like he was at the Community Solutions Halfway House, the Chase Center in Waterbury. I did, in the document I did present, he did do the timeout program for 45 days. He did successfully complete that in the past. He was at the Open Earth Halfway House in Hartford, and looks like Connecticut Renaissance in Bridgeport, and then at one point a few years ago, admitted to St. Vincent's Medical for a broken hip, which occurred at the Maple Street house. He did it as far as school. He had an appointment while he was out to take a tour at Manufacturing Alliance Service Corps in Waterbury to potentially attend and learn machine operating. Because of his issue with the civil settlement, he hasn't worked because of his medical state, and he did try to get a part-time job and apply for disability while he was out in the community. He does have primary care services established through Hartford Healthcare, the Wheeler Clinic's Family Health, and he did indicate to us December 20th of 2023, he did receive radiation and chemotherapy for the brain surgery injuries. And currently, reporting to my surgeon, he is medication compliant. He's taken all his medication for his health. It's indicated he's amenable to being placed in a halfway house or an inpatient program. Mr. Johnson, what part of the state would you like to be placed as far as a halfway house?
I'd like to be in the January Center in Augustville because I need treatment for that issue.
Okay.
And then possibly in Middletown at CVH for my mental health issues that I really need help on in inpatient. Because being in jail really, I don't know, it just doesn't, it's just sitting here and doing anything doesn't add up to treatment and getting better. So I'd like to actually try a little bit before my parole's over to actually get a little bit of help, other than just sitting around rotting away in a jail or out there doing nothing.
So Uncasville, I believe, is Norwich. Norwich. All right, so let's put Norwich District, and hopefully, as he indicated, if they can get them to Middletown at some point. All right, thank you, Mr. Johnson.
Thank you.
Anything further, counsel?
I don't have anything else to add regarding the background. Thank you.
Okay, I'm going to take a moment before I announce my recommendation.
May I just inquire from you? You have them, hopefully, paroles 8/25/23. Was this, he was, okay.
Yep.
Okay.
And then he's done June 19th, 2027.
Correct.
Okay, Mr. Johnson, I want to acknowledge that you were in the community supervised for about 9.5 months before you did abscond. However, this is your third violation, right? In addition to one top placement. And with those 3 violations that you did have, 2 of them were criminal, and this would be your second time absconding. Then, as stated here today, you went on a couple-month binge. I understand that you did go inpatient as well, but you acknowledge that there were some months that you were using. So with that all taken into consideration and being said, I recommend revoke and reparole on April 2nd, 2026, which is an approximate 18-month sanction. You still will have time on supervision because you're on supervision until June 19th, 2027. And I recommend the following conditions. no consumption of alcohol, no contact with victims SP, LP, BW, CC, and JM, no contact with minors without the express permission of your parole officer, general no contact with Key Bank in Fairfield, Connecticut, halfway house placement, and sexual behavior treatment. My findings and recommendations will be forwarded to the board. You will receive the official written decision from the board, and your board review is scheduled on January 2nd, 2025. So on January 2nd, 2025 is when the board's going to take a look at your case and make the final decision. They can lessen my recommended sanction, they can agree with my recommended sanction, or they can exceed my recommended sanction, being that, again, you're on supervision until 2027. Okay?
Okay,
All right, good luck, Mr. Johnson.
Thank you.
thank you. Have a good
Take care.
rest.
All set, see you. I'm all set. Yeah.
Good morning.
How we doing, guys? Good morning.
Good. Do you have Mr. Grant available?
I do. He's actually just walked in. Give me 1 second.
Thank you.
Date.
12/23/24. You can leave right there. It's fine. Come on in, have a seat. I'm sure the door of your privacy, but also air conditioning.
Good morning, Mr. Grant.
Good morning.
Hey, Jerry. My name is Officer Saunders. I'm a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Jerry Grant, 116571. Today is Monday, December 23rd, 2024. This hearing is being conducted via video of the Board of Pardons and Parole Central Office in New Haven Correctional Center. Please state your full name and DOC inmate number for the record.
Jerry Alfonzo Grant, 116571.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is your attorney.
Good morning, Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, Mr. Grant.
Good morning.
As well as your parole officer.
Parole Officer Babich.
Good morning, Ms. Babich.
Hi, Chair. This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony of today's hearing will be taken under oath. Mr. Grant, an officer, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury? I do. Thank you.
Yes, I do.
First, I will read you your rights. Then we will review the parole violation charges of the state your parole officer is bringing against you. Then I will review and identify exhibits filed for the record. The state will have an opportunity to present all relevant testimony and conduct cross-examination. Once the state is finished, your attorney will have the same opportunity. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, both the state and your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges of the state your parole officer is bringing against you and the information underlying each charge. Charge 1, obedience to the law.
On 10/4/24, Waterbury police responded to a suspicious person complaint. Upon arrival, they observed you naked on the porch, and the complainant stated that you were trying to force entry into her home via the back sliding door. She had surveillance footage of the incident, which she showed to officers. You were subsequently arrested and charged with criminal attempted burglary, 3rd, 53A-49, breach of peace, 2nd, 53A-181, criminal trespass, 1st, 53A-107, and voyeurs on 53A-189A.
Charge 2, drugs.
On or about 5/24/24, you used cocaine. On 7/14/24, you used cocaine. On or about 7/17/24, you used cocaine. On or about 7/18/24, you used cocaine. On or about 7/23/24, you used cocaine. On or about 9/18/24, you used fentanyl, norfentanyl, and cocaine.
And charge 3, halfway house placement.
On 7/14/24, you left the halfway house at 8:05 a.m. without permission after being told that you were on restricted community access. You returned at approximately 12:02 p.m. after being unaccountable in the community for approximately 4 hours. This is a violation of your halfway house agreement, which states, I will not leave the physical confines of the halfway house unless authorized by program staff or parole. On 9/23/24, you signed out of the halfway house at 4:30 p.m. on a community pass to your IOP group until 8:30 p.m. You failed to return or contact the halfway house, and your whereabouts in the community were unknown until your parole officer learned on 9/26/24 that you had been admitted to St. Mary's Hospital on 9/23/24 at 11:38 p.m. You did not attend your program and were unaccountable in the community for approximately 7 hours. This is a violation of your halfway house agreement, which states, I will only go to locations indicated on an approved community pass unless changes have been authorized by staff, and I will return to the halfway house from community pass at my scheduled return time. If I am unable to do so, I will call program staff to explain why I am expected to be late and to receive a new return time. On 10/2/24, you signed out of the halfway house at 4:30 p.m. on a community pass to your IOP group until 8:30 p.m. You failed to return or contact the halfway house, and your whereabouts in the community were unknown until you were arrested by Waterbury Police on 10/4/24. This is a violation of your halfway house agreement, which states, I will only go to locations indicated on an approved community pass unless changes have been authorized by staff, and I will return to the halfway house from community pass for scheduled return time. If I am unable to do so, I will call program staff to explain why I am expected to be late and to receive a new return time.
The state has filed the following exhibits, starting with Exhibit A.
Exhibit A, conditions 3/28/24. Exhibit B, parole violation report. Exhibit C, notice of parole violation. Exhibit D, notice of parolee rights. Exhibit E, remand to actual custody order. Exhibit F, halfway house agreement from 3/28/24. Exhibit G, Quest Diagnostics report collected 5/24/24. Exhibit H, Sierra Center client infraction report signed 5/31/24. Exhibit I, offender misconduct signed 6/17/24. Exhibit J, Sierra Center client infraction report signed 7/10/24. Exhibit K, Sierra Center client infraction report signed 7/14/24. L, voluntary admission signed 7/14/24. M, ADL report collected 7/17/24. Exhibit N, voluntary admission signed 7/18/24. Exhibit O, voluntary admission signed 7/23/24. Exhibit P, CASA letter from D. Penland. Exhibit Q, parole conditions from 8/27/24. Exhibit R, halfway house agreement from 8/27/24. Exhibit S, Quest Diagnostics report collected 9/18/24. Exhibit T, Central Ave incident report from 9/21/24. Exhibit U, Central Ave halfway house report or halfway house incident report from 9/23/24. Exhibit V, parole conditions from 10/1/24. Exhibit W, halfway house agreement from 10/1/24. Exhibit X, Renaissance East incident report from 10/2/24. Exhibit Y, Waterbury Police report. Z, continuance minimus, and Exhibit AA, judicial branch pending case detail.
The state filed an addendum to Exhibit B, which states on December 6, 2024, Mr. Grant received an unconditional discharge sentence for criminal trespass first. The charges burglary third, breach of peace second, and voyeur, aroused sex desire trespass was now under docket ending in 176. Counsel, did you receive the notice of parole violation report, and the other documents I will just mark for identification purposes?
Yes, I have.
Okay, and defendants also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today, we have no witnesses, and at this time, the state will have an opportunity to present evidence and speak to any of the evidence submitted.
I would just like to reiterate, like I was checking my initial recommendation, at which point I recommended the disposition of his criminal charges or for a minimum of 6 months. He's had numerous opportunities to complete inpatient. He does continue to struggle with his addiction and inability to succeed in the halfway house environment. He was not officially an absconder, but not living at the residence for 2 days prior to his arrest. So I do agree with my recommendation that even though the charges were disposed of, I would recommend a 6-month violation period.
Thank you. Counsel?
Yes, I've got no comment as to the preponderance standard regarding the criminal trespass conviction for an unconditional discharge, but there's no basis for the other charges. He was merely sleeping on the back porch. He was found clothed with his pants on at the time of the arrest. So there's no, it says in the report that he was naked. The police found him clothed. There's no evidence that he was naked. This is a simple criminal trespass. He was advised, unfortunately, by his attorney that would have no repercussions with respect to his parole violation. I spoke with him. I told him it could affect his parole violation, but he wasn't advised that prior to him pleading guilty. He would like to argue that for charge 2, he's already been given sanctions for those positive drugs screenings and interventions, and so that they shouldn't be considered again. That's his argument. I have no comment as to charge 3, except to say that he really wasn't unaccountable at 9/23. He was admitted to the hospital. And so I don't believe it meets the preponderance standard for the second part of charge 3.
Thank you.
You're welcome.
Officer, anything further?
No, not this time.
Okay, counsel?
No, at this point, we're done in the first part of the hearing.
Thank you. I'm going to take a moment before I announce my findings. Regarding charge 1, obedience to the law, I make a finding based on Mr. Grant's conviction, as well as state exhibits A, B, Q, V, Y, Z, and AA. On charge 2, drugs, I make a finding based on states exhibits A, B, G, H, I, K through Q, S, and B. On charge 3, halfway house placement, I make a finding based on states exhibits A, B, F, K, Q, R, U, V, W, and X. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney, as well as the state, will have the opportunity to speak to your background and history. Officer?
I think we're at this time. Okay, thank you.
Counsel?
They stated when he did leave on the 2nd, he was only gone for 2 days. He was sleeping on a porch because he felt he didn't have anywhere else to stay. Obviously, he could have been staying at the halfway house. He does have a cocaine addiction. There's no persons harmed in any way, shape, or form. There's no violence here. He needs treatment. He has relapsed in the past. His parole officer has talked to his continuous addiction to drugs. He's been in jail before. It's not going to cure his drug addiction. I understand that there have been chances at treatment. I don't believe there are a limited number of chances. It may take tens or 20s of times for numbers of times for people to be in treatment, for them to finally commit to treatment. So I don't believe holding him for an additional 3 months will meet any interest of justice here. He's gone to programs in the past. He's been at Wellmore in the past. I know he's had prior violations, but I don't believe this is so serious or sufficiently serious enough of a violation to warrant more than 3 months incarceration. That would be our position. We'd ask that it be released in early January. Thank you for your time and consideration.
Thank you. So take a moment before I make my recommendation.
Okay, well, that's 61. Right. East Lawn 33, last name is Connor. In West Lawn 65. What you say, honey? She's gonna bring over in a second. What are you working on? Right now, wherever, because I work on.
Okay, Mr. Grant, you were in the community for about 6 months of this period of your supervision. You did leave the halfway house. Your whereabouts were unknown for 2 days until being arrested. You've received 4 prior top placements. This is your third violation because you had 2 prior violations. And on this violation, you did receive a new conviction. Based off of all this information, I recommend revoke and reparole on October 6, 2025, which is a 1-year sanction with the following conditions: anger management, general no contact with Walgreens located on Meriden Road in Waterbury, Connecticut, a general no contact with TG, GH, EGC, and HO, halfway house placement, mental health evaluation. By finding the recommendation to be forwarded to the board, you will receive the official written decision from the board, and your board review is scheduled on January 2nd, 2025. At that time, the board can lessen my recommended sanction, let my recommended sanction stand, or impose a sanction longer than what I have recommended, being that you're on supervision until 2030. Okay, so that does conclude your revocation hearing. Counsel, anything? No. All right, thank you. You're all set.
Good luck, sir. The board will meet on the 2nd of January. please call us on the 3rd of January and we'll let you know what the board decided, okay?
Okay.
Thank you, sir.
More on. Yeah, but then you have to.
Good morning. My name is Officer Saunders. I'm a hearing member for the Board of Pardons and Paroles. This is a revocation hearing concerning Modesto Armenteros 372660. Today is Monday, December 23rd, 2024. This hearing is being conducted via video at the Board of Pardons and Parole Central Office at New Haven Correctional Center. Please state your full name and DOC MA number for the record.
Modesto Armenteros 372660.
This is a public hearing. Public access to this hearing is available via video live stream. Present this morning is also your attorney.
Robert Famiglietti, public defender from the Parole Revocation Unit. Good morning, sir.
Good morning.
This is a revocation hearing to determine whether you have violated the conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has a responsibility to prove the allegations by a preponderance of evidence. That is, the better or weightier evidence must establish that more probable than not the allegation is true. If I do not find that there's a preponderance of evidence to support a violation of one or more of the conditions of your parole, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find that you have violated one or more of the conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I will make a recommendation as to an appropriate sanction. My recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing will be provided to justify additional confinement. The testimony at today's hearing will be taken under oath. Mr. Armenteros, please raise your right hand. Do you solemnly swear or solemnly sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
Thank you. First, I will read you your rights. Then we will review the parole violation charges that the state, your parole officers, bring against you. Then I will review and identify exhibits filed for the record. Your attorney will have an opportunity to present all relevant testimony and conduct cross-examination. After considering all the evidence presented, I will announce my findings. If I find that you have violated one or more of the conditions of your parole, your attorney will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure before we begin?
Say that again?
Do you have any questions about the purpose or procedure before we begin?
No.
You have important rights at this hearing, which I now will review with you. You have the right to be represented by an attorney. You have the right to receive written notice of charges of violation. You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine adverse witnesses. Do you understand these rights?
Yes.
We now will review the charges that the state your parole officers bring against you and the information underlying each charge. Charge 2, no consumption of alcoholic beverages. On October 25th, 2024, at approximately 9:30 p.m., you were observed operating a motor vehicle in a reckless manner. You were subsequently pulled over by Derby police officers and were observed with glossy and bloodshot eyes, along with the smell of alcohol emanating from your breath. A bottle of tequila was also observed in your vehicle. Due to this, officers conducted a field sobriety test in which you were unable to complete them to standard. Additionally, you submitted a chemical breath test, which provided results of 0.1617 BAC and 0.1669 BAC, both of which exceeded the legal limit. You were subsequently arrested by Derby Police Department and charged with driving under the influence and reckless driving. Due to this, you are in direct violation of TCS condition, alcoholic beverage consumption. The state has filed the following exhibits. Exhibit A, CT remand to custody. Exhibit B, CT signed conditions of parole. Exhibit C, notice of parole violation and parolee rights. Exhibit D, parole violation report. Exhibit E, Derby Police Department reports. And Exhibit F, State of Connecticut judicial documents. The state found an addendum to Exhibit D, which states on November 21st, 2024, Mr. Armenteros appeared in GA 5 Court in Derby under docket ending in 274 for the charges of operation while under the influence of liquor or drug, or while having an elevated blood alcohol content, and reckless driving. Mr. Armenteros was granted admission into the diversionary program by the court. Because he was granted admission into the diversionary program, PCS withdrew the re-imprisonment warrant charge regarding charge 1, obedience to the law, to afford Mr. Armenteros the opportunity to participate in the court-ordered program. Counsel, did you receive the notice of parole violation report, and other documents that were marked for identification purposes?
Yes, I have.
Today we have, defense has also filed Exhibit 1, parole accomplishments and future plans for parole reinstatement. Today we have no witnesses, and it is now the defense opportunity to present evidence and speak to any of the evidence submitted.
Regarding the preponderance standard, as the judge, too, I have no comment.
Thank you. Regarding charge 2, no consumption of alcoholic beverages, I make a finding based on state's exhibits B, D, and E. That concludes the fact-finding portion of this hearing. Before I make my recommendation, your attorney will have an opportunity to speak to your background history. Counsel?
Thank you. Consistent with PCS's decision to allow my client to enter the program and receive treatment as opposed to jail and a sanction, we'd ask that he be released on the first available date. The board is leaving, his parole officer has left this up to the board. He was on parole. This is his first violation for 2 years and 8 months prior to this arrest. This was a slip. He has no past alcohol issues. This is nonviolent. There was no accident. He was cooperative. He's a sole occupant. We believe a January 2nd release date would be most appropriate here. He is a 41-year-old male. He receives support from his stepfather, sister, 2 brothers, nieces, and nephews. He has 4 children, 27, 24, 12, and 9. He has a history of construction work. He worked full-time at Bazzuto's for 2 years. In Cheshire, full-time for Corporation for Public Management, CPM, in Waterbury. It was a day program that served those diagnosed with developmental disabilities. He was employed there for 7 months at the time of the remand, working with others with disabilities. He's completed an intake of Connecticut Renaissance in the past, completed Explore in the past. He was on a minimum contact schedule. He wishes to be sponsored by his significant other, Tracy Coggins, in Naugatuck. He wishes to attend tractor trailer training school, obtain his CDLA, and he is free to return to his position at CPM, helping those with disabilities. We see no reason whatsoever to continue to hold him in jail. He is ready, willing, and able to deal with his choice to drink alcohol and drive. It is merely the no alcohol provision upon which this is based. First violation. Thank you for your time and consideration.
Thank you. I'm going to take a moment before I announce my recommendation. Being that this is you have no prior violations, you are in the community for over 2 years on special parole. And per the report, there's no reports of any misconducts. I recommend revoke and reparole on January 2nd, 2025, which is an approximate 2-month sanction with the following conditions: no consumption of alcohol, domestic violence, no contact with victims MM or SL without the express permission of your parole officer, halfway house placement. My findings and recommendations will be forwarded to the board. You will receive official written decision from the board, and your board review is scheduled on January 2nd, 2025. On that day, the board can agree with my decision, and being that you're on special parole, you would be released that day, or they can impose a sanction longer than what I have recommended. If they do impose a sanction longer than what I have recommended, then a supplemental hearing will be taking place to address why they would want additional confinement, okay?
Okay,
So if you're not released on the 2nd, give me a call,
okay.
okay? All right, sir.
I'll get all the details. Okay,
Good luck.
thank you.